think for a second about how an idea, just a thought, ends up becoming a law that shapes all our lives here in England and Wales. It's not some overnight magic trick. It's actually, well, a surprisingly complex and fascinating journey.
It really is, with twists and turns you might not expect.
Yeah.
And that's exactly what we're diving into today. Forget the sort of dry textbook approach. We're on a mission, you could say, to understand the real engine room of our legal system. Acts of Parliament.
Right, the big hitters.
They are the big hitters, absolutely. The most powerful laws we have. We'll trace their path, from the initial concept all the way through to being enforced.
And uncovering some history, too.
Definitely. Some really interesting historical context and procedural secrets along the way.
Exactly. So whether you're trying to get your head around the basics of how the country's run, or maybe you need to know this stuff for something specific, or perhaps you're just fascinated by how things work behind the scenes.
Which many people are.
Absolutely. This deep dive is for you. We're aiming to give you some valuable insights without getting lost in, legal mumbo-jumbo.
Sounds good.
Okay, so Acts of Parliament, these are the undisputed champions of law, right? The top tier.
They truly are. Acts of Parliament, sometimes called statutes, they form the bedrock, the absolute foundation of the legal framework in England and Wales.
Okay.
They address such a vast range of issues, really, from the grand scale of national policy right down to some very, very specific regulations.
And these acts, they don't operate in a vacuum, do they? Because we often hear about other types of legal rules and regulations.
That's a really good point. No, they don't. We also have what's known as secondary legislation.
Secondary legislation, okay.
Think of things like bylaws that your local council might pass about parking, perhaps, or statutory instruments often just called sus.
Cassess, right, I've heard that term.
Now, what's absolutely key to understand here is that these secondary laws, they don't just appear out of nowhere. They are actually created using powers that Parliament specifically grants within an act of Parliament itself.
Ah, okay, so Parliament sort of sets the framework.
Exactly. It's like Parliament sets the broad rules of the game and then delegates the authority to others, like a government minister, to fill in the more detailed specifics.
That delegation makes a lot of sense. I mean, Parliament can't possibly micromanage every single tiny detail, can it?
No, absolutely not. It would grind to a halt.
Can you give us a real-world example just to see how that works in practice?
Certainly. Let's take the Immigration Act 2014, a fairly recent one.
Okay.
Within that act, specifically in Section 70A, Parliament basically stated, and I'm paraphrasing slightly, that the Secretary of State may, by regulations, provide for a charge to be imposed on persons who make immigration skills arrangements.
So the act itself created the power to make rules about this charge.
Precisely. It didn't set the charge amount or the exact rules. It just created the power for the Secretary of State to do so later via regulations.
And then the Secretary of State used that power to create. What?
Exactly. That power then led to the creation of the Immigration Skills Charge Regulations 2017.
Got it.
And that is a statutory instrument. It's a piece of secondary legislation. It lays out all the specific details. Who pays the charge, how much it is, the procedures involved, all that stuff.
That's a perfect illustration. So Parliament sets the high-level policy, the act, and then empowers others to enact the practical details through these SIs.
You've got it. That's the relationship.
Okay, so acts of Parliament are the big picture law, the primary source, and then you've got these more detailed rules, secondary legislation, that flow from them. Now, the legal system in England and Wales, it's been around for a while, to put it mildly.
Yes, just a bit.
It's not like this all started yesterday, is it?
Absolutely not. And to really appreciate the authority that Parliament holds today, you really do have to look back at the long sweep of history.
Yeah. What's truly remarkable, I think, is that the oldest piece of legislation that is still in force, still technically law in England and Wales, is the Statute of Marlborough.
The Statute of Marlborough, when's that from?
It dates all the way back to 1267.
1267, wow. That's
That's
incredible. So what does it tell us that a law from the 13th century is still on the books?
Well, it highlights the incredible longevity, doesn't it? And the gradual evolution of our legal system. It wasn't a sudden revolution.
A gradual shift.
Exactly. Over those centuries, as we touched on earlier, there was this fundamental change in who held the authority to actually create laws. It's slowly, sometimes painfully, moved from the monarch, the king or queen, towards Parliament.
And a real turning point in that shift, in solidifying Parliament's power, that was the Bill of Rights, wasn't it?
Precisely. The Bill of Rights of 1689 was a truly landmark moment, a cornerstone.
Okay.
It firmly established Parliament as the supreme lawmaking body in the land. The monarch's role in creating legislation became, well, largely a formal one after that.
Just signing off on it,
Okay.
essentially. Pretty much. The granting of royal assent to a bill after it has successfully passed through Parliament. It's a crucial symbolic step, yes, but the real power to debate, to amend, to decide on the content of laws that now lies firmly within Parliament.
So Parliament is where the legislative action happens.
Yeah.
What exactly is Parliament? Because it's not just a single entity, is it?
No, that's right. It's actually made up of three distinct parts, all housed in that famous building, the Palace of Westminster.
Okay, 3 parts.
First, you have the monarch, currently the king. His role is mostly formal now, as we said.
Right.
Then there's the House of Commons. Its members are directly elected by the public in general elections. We call them members of parliament, or MPs.
The elected part.
The elected part, yes. And finally, there's the House of Lords. Its members are generally referred to as lords or peers.
Lords and peers.
Yeah.
Okay. And each of these chambers, the Commons and the Lords, they have someone in charge to keep things running smoothly, keep the debates on track.
Exactly right. Both the House of Commons and the House of Lords have a speaker.
A speaker.
Their role is absolutely vital for maintaining order during debates,
Yeah.
ensuring that everyone gets a fair chance to speak, calling MPs or lords to order if needed, and generally overseeing the proceedings of their respective houses. It's a tough job.
I can imagine. Okay, so we've got the key players in Parliament.
Hmm.
Monarch, Commons, Lords, Speakers. Now the big question, how does a bill, an idea for a law, actually make its way through this system and become an act? It sounds like quite the obstacle course.
It is. It's a detailed and quite rigorous multi-stage process. And a crucial point right at the start is that a bill has to go through broadly the same stages in both the House of Commons and the House of Lords.
Both houses. Okay.
Yes, it can start its journey in either house, though many major ones start in the Commons. But once it successfully completes all the stages in one house, it then moves on to the other house to go through the exact same process all over again.
Right, so double scrutiny. What's the very first hurdle a bill has to clear then? What's stage 1?
That's called the first reading. It sounds quite grand, but honestly, at this stage, the title of the bill is simply read out in the House.
Just the title.
Just the title. And an order is made for it to be printed and made publicly available so members can see it. It's usually a very formal, very brief, and generally uneventful initial step. More about officially putting the bill on the agenda.
Okay, so more of a formality, title read, bill printed. What comes next in this legislative marathon?
Next up is the second reading. This is much more substantial.
Okay.
By this point, all members of the House MPs or Lords will have had the opportunity to read the bill and understand its main proposals.
So they've done their homework.
Hopefully. The second reading is when the fundamental principles and the overall purpose of the bill are debated by the members. It's the big picture debate. Do we agree with the general aims of this bill? It's a chance for them to express their broad support or opposition.
So the main ideas get debated at second reading. If it passes that, then we get to the committee stage, which sounds like where the real fine-tuning happens.
Absolutely. The committee stage is critical for detailed scrutiny. After the second reading, the bill is usually sent to a committee.
The smaller groups.
Yes, typically a smaller group of members drawn from across the main political parties within that house. Now, the exact type of committee can vary a bit. In the House of Commons, most bills go to what are called public bill committees.
Public bill committees.
But their core job is the same, to scrutinize the bill in minute detail, what lawyers sometimes call clause-by-clause examination.
Clause by clause. Sounds intense.
It is. They go through it line by line, sometimes word by word, looking for ambiguities, potential loopholes, unintended consequences, or areas that might need clarification or amendment.
And who sits on these committees? Is it just government MPs?
No, crucially, these committees reflect the party balance in the House. So you'll have members from the government party, the main opposition, and often smaller parties, too. A smaller number of really important or constitutional bills in the Commons might go to a committee of the whole House, which means all MPs can participate directly in this clause-by-clause debate on the floor of the chamber.
Okay. And the Lords.
Interestingly, the House of Lords works slightly differently here. They don't use public bill committees in the same way. Instead, the committee stage for any bill in the Lords usually involves the whole House. Any Lord can participate and propose amendments.
Right. And I can imagine this committee stage is where things can get Well, a bit bogged down sometimes, where opponents of the bill might try to make changes or just slow things right down through lengthy discussion.
Precisely. That can definitely happen. Opponents can certainly use the committee stage to try and amend the bill significantly, perhaps water it down, or even just to highlight perceived flaws through very detailed, lengthy debate. Filibustering, essentially.
So how is that managed?
Well, the chairman of the committee plays a vital role here. They have the authority to decide which proposed amendments will actually be debated. And often, particularly for larger bills, a business subcommittee will allocate a specific amount of time for debating different parts or clauses of the bill, a timetable, basically.
A timetable. Okay.
Yeah.
Stops it going on forever.
Exactly. It tries to ensure progress.
Right, so a lot of detailed examination, potential for changes, maybe some political maneuvering. After the committee has done its deep dive, what's the next step? Where does the bill go then?
That's the report stage, quite logically named.
Report stage. Makes sense.
The committee formally reports back to the entire House of the Commons or the Lords, outlining any amendments they are recommending based on their scrutiny.
So they present their findings.
Yes. The Speaker of the House then reviews this report and schedules time for a debate on the suggested changes back in the full House. This is important because it gives members who weren't on that specific committee a chance to consider and potentially debate the amendments proposed by the committee. New amendments can sometimes be proposed at this stage, too.
Ah, so another chance for debate on the changes.
Hmm.
Amendments debated, potentially voted on. We must be getting closer to the end of the process in that House.
We are. What follows the report stage is the third reading.
Third reading, the final look.
Pretty much. At this point, the bill is considered in its final form, incorporating any amendments that have been agreed upon during the committee and report stages. It's really a chance for the House to take one last look at the entire bill as a package deal before a final vote is taken on whether to pass it or not. Debate at third reading is usually much shorter and focused on the overall merits of the bill as amended.
Okay, so it's potentially passed through one House after first reading, second reading, committee stage, report stage, and third reading. Phew. But as you said right back at the beginning, it's only halfway there at best, isn't it?
Exactly right. It feels like a marathon, but it's only the first leg. The entire process, first reading, second reading, committee stage, report stage, and third reading then has to repeat in the other House of Parliament.
Wow. So if it started in the Commons, it goes through all that and then starts all over again in the Lords.
Precisely. It has to successfully navigate all those stages again and, crucially, be agreed upon in the exact same wording, the same form, by both the House of Commons and the House of Lords. If the second House amends the bill, it has to go back to the first House for them to agree the changes. This back and forth is sometimes called ping pong.
Ping pong. Okay, that sounds like it could get complicated. Double the effort, double the scrutiny. And once it has finally cleared both of those hurdles, maybe after some ping pong, what then?
After being passed by both the House of Commons and the House of Lords in an identical form, the bill reaches the very final stage. Royal assent.
Royal assent, the monarch's approval.
Yes. This is when the monarch, the king, formally gives their approval to the bill. It's largely a formality these days, governed by convention. No monarch has refused royal assent for over 300 years.
300 years. Okay, so it's pretty much guaranteed.
It is. Once royal assent is granted, usually signified in a ceremony or simply notified to Parliament, the bill officially becomes an act of Parliament. Its provisions become law.
And when does it take effect? Immediately.
It takes effect immediately upon receiving royal assent unless a specific later date, known as a commencement date, is outlined within the act itself. Often different parts of an act come into force at different times.
Right. It's a long and intricate journey then. Clearly designed to ensure thorough scrutiny, wouldn't you say?
Absolutely. Lots of checks and balances built in.
Now, let's turn our attention a bit more to the House of Lords. You mentioned it earlier. It's often described, sometimes critically, as an unelected chamber, which feels a bit out of step with modern democratic ideals, doesn't it?
That's a really important point, and it's a source of ongoing debate. Unlike the House of Commons, where, as we said, members are directly elected by the public, the House of Lords has a very different composition.
How so?
Well, it's made up mainly of two types of members these days. First, there are still some hereditary peers, people who inherit their title and the right to sit in the House from their family, although their numbers were significantly reduced by reforms in 1999.
Okay, hereditary peers, a smaller number now, and the others?
The vast majority now are life peers. These are individuals appointed by the monarch, but really on the advice of the prime minister usually in recognition of their expertise or significant contributions to various fields, things like business, culture, science, medicine, law, public service.
So people appointed for their experience.
That's the idea. And crucially, these peerages are for their lifetime only. They are not inherited by their children.
Okay. But there's often a perception, isn't there, maybe a criticism, that these appointments,
Yeah.
particularly the life peerages, can sometimes be influenced by political donations or affiliations, sort of cash for honors.
There's certainly a public perception and, frankly, ongoing debate and sometimes controversy around the process of appointing life peers. It's not uncommon for individuals who have made significant financial contributions to political parties or who have served parties loyally to be nominated for peerages.
Right.
And this naturally raises questions about potential influence, cronyism, and whether the appointments are always based purely on merit and expertise. There are calls for reform of the appointments process.
So while the theory is that the lords bring valuable experience and knowledge to the table, acting as a revising chamber,
Yes, providing that second look based on expertise.
they're not directly accountable to the public through the ballot box like MPs are.
Precisely. That's the fundamental difference. The underlying principle is that the House of Lords can provide a valuable function, bringing diverse expertise, specialist knowledge, and often a longer-term perspective, perhaps less swayed by immediate political pressures, to the legislative process. They often do very thorough work scrutinizing bills.
Idiotic.
But the fundamental point remains that the vast majority of its members are not democratically elected by the people whose lives are governed by the laws they help shape.
And you mentioned this has become a growing point of discussion, particularly over the last couple of centuries. Why the increased focus now, or relatively recently, on this unelected element?
Well, I think over the past couple of hundred years especially, democratic principles, the idea of government by the people for the people, have become increasingly central to how we think about legitimate government, not just here but around the world.
Right, the rise of democracy.
Exactly. The idea that those who make the laws should be directly accountable through elections to the people they govern has become more and more ingrained in our political culture.
So an unelected chamber looks odd.
In that context, yes. The existence of a powerful legislative chamber, one that can amend or delay laws passed by the elected commons, where most members are not elected, naturally raises questions about democratic legitimacy and the proper balance of power in the 21st century.
It creates a potential tension, then, between the elected commons and the unelected lords,
Yep.
which I suppose is where the Parliament Acts of 1911 and 1949 come into play. Were they designed to address some of those concerns?
Exactly right. The Parliament Acts, particularly the one in 1911, which followed a major clash between the Liberal government and the conservative-dominated Lords, and then the subsequent 1949 Act, which further reduced the Lords' power, were a direct response to this very issue.
The imbalance of power.
Yes, the perceived imbalance of power between the elected House of Commons and the unelected, largely hereditary at the time, House of Lords. These acts establish what's known as the Parliament Act procedure.
The Parliament Act procedure. Okay, what's that?
This procedure, while actually quite rarely invoked in practice, acts as a crucial constitutional safety valve. It essentially ensures that the democratically elected will of the House of Commons can, ultimately, prevail over the objections of the House of Lords in most legislative matters.
So it limits the Lord's power to block things indefinitely.
Yes, it limits their power to delay. Think of it as ensuring that, particularly on matters of significant public importance or where the government has a clear mandate, the elected chamber gets the final say.
And what does this Parliament Act procedure actually allow the House of Commons to do, specifically?
Essentially, it allows the House of Commons, under specific conditions and after a certain period of delay imposed by the Lords, usually about a year, to send a bill for royal assent without the consent of the House of Lords.
Ah, so they can bypass them if necessary.
Under those specific circumstances, yes. So while the Lords still play an important and often very valuable role in scrutinizing, debating, and amending legislation, the Parliament Acts provide a mechanism, a constitutional backstop, to ensure that the elected chamber ultimately has the final say in most circumstances.
It's a way of upholding the democratic principle, then, that the elected body has the ultimate authority.
That's the core idea behind it. It's a compromise, really, balancing the traditional role of the Lords with the primacy of the elected commons.
So it's a mechanism to balance the power, ensure the elected voice can ultimately be heard. This has been a really insightful journey, actually, through the sources of law, focusing particularly on the power and the detailed process behind Acts of Parliament.
It's quite a process, isn't it? We've seen that Acts of Parliament truly are the supreme source of law in England and Wales, primary legislation.
Definitely. And their creation isn't simple. It's a detailed, carefully structured process involving multiple stages, checks, balances.
In both the democratically elected House of Commons and the largely unelected House of Lords, culminating in that symbolic royal assent from the monarch.
We've also touched on the really deep historical context that led to Parliament's current power, going way back.
Back to Magna Carta and beyond, really.
Explored the three key components of Parliament, monarch, Commons, Lords, and walked step by step through the intricate legislative journey a bill must navigate to actually become law.
Indeed. And we've highlighted the unique role and, let's be honest, the sometimes controversial composition of the House of Lords,
Yeah.
as well as those crucial Parliament acts that provide that mechanism to navigate potential disagreements between the two houses, reflecting that ongoing tension, really, between tradition and modern democratic principles.
So here's a final thought, perhaps, for you, the listener, to consider.
Yeah.
Reflecting on this carefully constructed system, this historical balance or maybe imbalance of power between the elected House of Commons and the unelected House of Lords, how does this whole setup, this historical compromise, truly shape the laws that govern our daily lives?
That's a great question.
And what are the ongoing debates surrounding its legitimacy and its effectiveness, really, in our modern democracy today? It's a complex and constantly evolving picture, isn't it?
It certainly is. Never stands still.
Hopefully this deep dive has given you a much clearer understanding of the fascinating and sometimes quite winding journey a law takes here in England and Wales.